Jacob Stern. I'm a junior at Branson Everglades. About 3 summers ago, I was taking a class at the University of Georgia, and the class was called Criminal Law and Mock Trial. We spent a lot of time talking about criminal law and its effects on adults primarily. We talked about murders and thefts and other big crimes like that. But I asked my teacher one day, what about like little crimes, crimes that teens commit on a daily basis and how they can affect a teen's life? So for the next several days, we really talked about crimes like possession of marijuana or alcohol or open house parties or driving infractions that really affect teens and the effects that it can have on the rest of the teen's life, the ramifications. So after talking about that, I came home, I talked to my mom, who's a judge, and we really decided that teens aren't really aware of the simple mistakes that they can make on a daily basis and the effects that that simple mistake can have on the rest of their lives. So I talked to my friends and I asked around, how many of you know a ramification or know how one hiccup with the law can really ruin your college opportunities, your career opportunities, and really your life? And a lot of them really didn't know. So I talked to my mom again, and we decided to go to different high schools and educate teens primarily about little effects that they make on a daily basis and how those effects can really affect the rest of their lives. So we came up with a list of teen mistakes when we place you in adult criminal court, and what we go through is the top 10 mistakes that teens make on any given day, their run-ins with the law, and how it can affect them for the rest of their lives. So this is called Jacob's Top 10. We go through the 10 most common mistakes.
Let's talk a little bit about your criminal record.
So first off, the 2 biggest opportunities in a teen's life are arguably college and their future career opportunities. So this is really going to be a recurring theme, how these simple mistakes can affect a teen's college opportunities and career opportunities.
Because we know that the opportunities for college, if you have a criminal record, can affect the college of your choice, a scholarship, financial aid, career, obviously employment with a state agency, with the military, employment with a seaport or an airport. So we're going to talk about some of those offenses that can give you a criminal record, but most important, place you in adult criminal court.
So first off, let's just talk about juveniles in Florida. In Florida, there's a little over 31,000 juvenile arrests every single year. There's about 86 teenagers getting arrested on any given day for any given infraction. About a third of them involve drug arrests. Over 10,000, it's about 26 a day. Teenagers who make simple mistakes, a little possession of marijuana or anything like that, are drug arrests. But then for the driving under influence, it's only about 221. That's less than 1 a day. But when you think about the severity and the seriousness and the danger that teen is putting on their own life and on the lives of others, it's actually quite significant. And then a little over 1,100 liquor law violations. That's about 3 a day. What's even more important than any of these is that Florida is the #1 state in the country who processes the amount of teens from the juvenile division to the adult division. Meaning if you're a teen, you get arrested in Florida, you have most chance of any other state to be transferred into the adult division. So aside from the common misconception that I'm a teenager and I'll go into the juvenile system and it'll wash away my record, even worse than that, especially in Florida, you have an even higher chance of going into the adult system.
And when we see these numbers, this is from 2011, the Florida Department of Law Enforcement, these are juveniles, individuals between the ages of 12 and 17. And while we'll see that some of these offenses may start in the juvenile division, they may ultimately end up in adult court if there is a violation. Some of you teenagers may think that if you get arrested, it's a slap on a wrist. And that after that slap on your wrist, no one's ever going to know about your juvenile arrest record. And it's not the case. Your juvenile arrest record is not confidential if the arrest resulted in a felony, 3 or more misdemeanors, or it's transferred to the adult system. And as we'll see, some of the charges will automatically start in the adult criminal system. As Jacob said, the state of Florida transfers, it's the #1 state in the nation that transfers cases to the adult court system. And while Florida's population is half that of California, we transfer youth to adult court at a rate of 8 times that of California. In focusing on the juvenile arrest reports, you should know that there is a Florida law that states that while the Florida Department of Law Enforcement is the official keeper of the criminal arrest records in Florida, and the law provides that certain juvenile arrests are confidential, the law also gives the Florida Department of Law Enforcement to sell the information to the public. And that would include a booking photo or an arrest affidavit. And some employers actually attempt to get around the confidentiality of a juvenile record by asking the question on an employment application, have you ever been arrested? Sealing and expunging a record, it's actually a complicated area of the law. But let's talk a little bit about it, because some of you may think, well, I'm a juvenile, my record is going to automatically be expunged. And there is an automatic expungement expunction in the state of Florida at age 24, depending upon the type of offense, or age 26. But when a record is sealed, the public will not have access to it through the government databases. Agencies, including the police and the military, have a legal right to access the criminal history record, even if it's sealed. When a record is expunged, which we think of expunged being legally erased, their only access through that record is through a court order. And it's only available in expunction if the charge is dropped, or it's withdrawn, which is a nolle pros, or it results in a not guilty verdict. You're not eligible for either if you have been adjudicated guilty. You get one per lifetime. But even if your record is sealed, that record is still accessible to employment with a criminal justice agency, admission to the Florida bar, employment or licensing by a public agency, employment with a school or university, or even the purchasing of a firearm.
Let's talk about college opportunities. And for most of you teenagers, if you don't know what the Common App is yet, you'll learn about it when you start applying to college. It's accepted by 488 universities in the nation. It's the most used application process for college. So when you get to your senior year, chances are to start using it. And the question they ask you on the Common App is, have you ever been adjudicated guilty of a misdemeanor, felony, or other crime? Now, the Common App is actually quite generous compared to other colleges when they ask have you ever gotten in trouble with the law? Because they ask specifically, have you ever been adjudicated? Have you ever been found guilty? So for most of you, like my mom just brought up, if your record is sealed or expunged, or you go through a diversion program, you don't have to answer yes to this question. However, in Florida, most of us will be looking to Florida universities. So if we take UF, for example, this is what they ask. Have you ever been charged with a violation of the law that resulted in, or still pending, could result in probation, community service, a jail sentence, or the revocation or suspension of your driver's license? So this isn't asking, have you ever been found guilty? Have you ever been adjudicated? It's simply asking, have you ever gotten in trouble with the law, and has there been a consequence?
Florida now has a civil citation program, so you're legally not arrested. The question is, have you ever been charged with a violation of the law? So while you're going through that civil citation or diversion program in the juvenile division, you've been charged with a violation of the law. And what that includes is 6 months of testing. You'll have your analysis, and your analysis should come back negative. You'll have a substance abuse class and some community service hours, and you will have to keep up your grades in school. But if you do not comply, then there will be an arrest, and the state can file those charges. Let's go to Jacob's top 10.
So the first thing we're going to talk about is cyberbullying. This is the legal definition: sending someone a mean or threatening email, an instant message, or a text message, or if you break into someone's account to send cruel or untrue messages, if you try to impersonate someone on the web. So cyberbullying actually is a quite serious infraction.
And bullying has obviously expanded beyond the playground and into the personal space of students, and that's where it gets personal, and that's where we hear those tragic stories. And for many parents, the internet has not, and is probably not now, a big part of our lives, but for teenagers, it's a big part of their social life, and the effects can be devastating. And we've all heard the tragic stories. That is, we heard the story of Megan Mayer. Some of these were widely publicized. A high school student who hanged herself at the age of 13 after a boy she had become friends with on a social networking space, which was MySpace. It was a hoax that was the creation of a neighborhood mother, daughter, and another girl. And then the case of Tyler Clemente. We know that the defendant was just recently sentenced after being found convicted of 15 criminal counts, including invasion of privacy. But unfortunately, Tyler Clemente, who was a Rutgers University freshman, his college roommate used a webcam to spy on him having relations with another man. And Tyler, embarrassed by the students who saw the video on the internet, jumped off the bridge, falling to his death. And in Lee County, right here, right across the state of Florida, 15 and 16-year-olds set up a fictitious Facebook account on a classmate's name and posted fake nude photographs of her. Both faced felony charges of aggravated stalking. Let's look.
Take a look. Deputies say these are real-life mean girls. The two teens are in big trouble, busted by the FBI and Lee County Sheriff's Office for cyberbullying through the popular social networking site Facebook.
The sole purpose of this page was to terrorize and embarrass our victim.
Deputies say the 16-year-old victim had no idea. They tell us it started as a rift between the one-time friends. 16-year-old Taylor Wynn and 15-year-old Mackenzie Barker and the victim all went to Estero High School. A student we spoke with says Taylor has since transferred.
But I know Taylor, she's a nice girl. I mean, kind of surprises me.
Deputies say the girls created the Facebook page last April to bully their classmate in a vicious way. We can't repeat what the posting said, but they inferred that the girl would be willing to perform various sex acts on men in the 239 area code. According to reports, it was another Estero High School student who told authorities about the inappropriate page. It was shut down within a week. Detectives say they then created a second Facebook page attacking the girl yet again. It too was shut down. As for the reason, the arrest report says that Taylor Wynn told deputies she made the fake pages as a joke because, quote, nobody liked her.
It's a crime. This isn't just kids making fun of each other, poking fun of each other.
No answer at Taylor's home when we went to ask about the felony charges. Sadly, deputies say the victim found out about the online attack from other students. The page had more than 150 friends.
Now, these two teenagers each faced one count of a third-degree felony of aggravated assault. Ultimately, they entered into a diversion program that included 21 days of home confinement.
43% of kids have been bullied while online, and one in four have had it happen to them more than once. And 53% of kids have admitted saying something mean or hurtful to another person online. More than 1 in 3 have done it more than once. So it occurs quite frequently, and in fact it is a crime, and it can get you in trouble.
And 58% have not told their parents or an adult about something that mean or hurtful has happened to them. In 2008, Florida enacted the Jeffrey Johnson Stand Up for All Students Act. And it's a law that requires all schools, kindergarten through 12, these are public schools, to draft and implement a statewide anti-bullying policy and a procedure to safeguard all students. Jeffrey Johnson, unfortunately, in 2005, he was 15 years old, and he was the target of bullying both in school and online. And in June of 2005, his mother, Debbie, found her 15-year-old son hanging from his book bag strap in his closet. It was devastating, but she took it as her mission to educate schools and ensure that nothing like that would happen to any other child. The cyberbullying is an aggravated assault, and it is a felony that you can face up to 5 years in state prison. A form of cyberbullying is sexting. This is the definition of sexting, which is minors trading explicit messages or images via a cell phone or a social networking site, and it has significant consequences, although not as bad as it used to. Before 2011, the consequences were severe, and what happened in 2011 is our legislature addressed a troubling element of what we see as the teenage cyberculture, and that is that a 14-year-old girl caught sending an image to her teenage boyfriend is not a hardened criminal. Most recently, less than a year ago, a story was reported of a 4-year turmoil that no parent or child should ever have to wrestle with. What happened in that case is computer hackers violated a 14-year-old girl, Angie, her privacy when she had uploaded photos to an account, a photo bucket account. Is anybody familiar with a photo bucket account? Well, she placed photos on her private photo bucket account, and among the pictures was Angie posing in a bra and panties. It was meant only for her then boyfriend to see. Well, you can guess what happened. Many of her friends, like you, were probably doing the same thing, sending pictures that they thought were sweet and cute to individuals, not meaning any harm, just innocent behavior. But the posting of those pictures ended up going somewhere where she didn't think they were going to go. And many of you may know friends that post provocative pictures or pictures that they think are cute on a Facebook wall or in an electronic place that basically is an electronic thumbprint. That is, it's permanent. Well, what happened was Angie's account was hacked, and 6 months later, a friend sent her a note that her picture was on a porn site. And over the next 4 years, Angie became not only an unwitting, but an unwilling internet sex symbol. Her picture went viral and it took a life of its own. It made its way to pedophile sites, and within weeks, classmates and teachers knew about the photos. Some called her a slut and a porn star. She ended up leaving her high school, went to another high school, and the torment was worse. She was stalked and threatened. She had to leave her job at the mall when male voices called the managers, finding out when she was going to be working. Eventually, she left the school and is now homeschooled. And if you now Google her name, you get more than 1 million hits. Devastating consequences.
Now let's go on to our second topic, which is marijuana. As previously mentioned, about a third of all Florida juvenile arrests deal with drugs, and most of them are marijuana. So we're going to talk about what is the punishment for marijuana, and we're also going to talk about fake pot. And as we're going to show you next, pot really is a big deal, and it comes with serious consequences.
Right now, marijuana, possession of marijuana, 20 grams or less is a first-degree misdemeanor, up to 1 year in the county jail and a $500 fine. More than 20 grams is a third-degree felony. That obviously carries with it a maximum penalty of 5 years in state prison and a $5,000 fine. If it's filed in the juvenile court, as we stated before, more than likely the juvenile, if never involved in the criminal justice system, will go through a juvenile diversion program. But that will be a long process, and that juvenile will need to be drug tested, will need to go to a substance abuse court. And if that juvenile violates that program, the prosecutor can file adult criminal charges. So let's think about possession of marijuana. For those of you that think, well, okay, marijuana is not really a big deal. If someone comes in my car and he or she, but my passenger, is smoking a joint, but I don't have anything to do with it. All I'm doing is driving. Let's consider this scenario. You're driving. You're stopped for a traffic citation. What happens? What happens? The officer's going to come up to your window, right? You're going to have to roll down that window, and then what happens? The officer's going to smell the marijuana, so there's a strong odor of cannabis. So that's already giving the officer probable cause. So what's the officer going to do? He's going to ask you to step out of the vehicle. Now he's going to ask where the marijuana is. Does anybody believe that your passenger is going to own up to it and say that was mine? Remember, possession is a question of fact. When it's not in the actual possession, and it's in the constructive possession, it's readily accessible, and it's in the vehicle, and you're driving the vehicle. You may own the vehicle, or your parents may own the vehicle. There's a problem with it, and you will be arrested for possession of marijuana, because if nobody's owning up to it, what's going to end up happening? You're both going to be arrested, and therein is where the problem is. So let's look at marijuana, because there's a lot of talk about the synthetic.
So let's talk about synthetic cannabinoids, or also known as fake pot. So the definition is a man-made psychoactive and herbal chemical product which can mimic the effects of cannabis when consumed. So as the government legalizes more and more drugs such as marijuana, people try to cut corners, they try to get around it by creating these kind of fake drugs, these synthetic drugs. The most common example of these fake pots or synthetic cannabinoids are Spice and K2. They're readily available everywhere on the market. But in 2011, during the Florida legislative session, they actually made Spice, K2, and other examples of synthetic cannabinoids illegal. And actually, there are stronger punishments for these drugs than actual marijuana. 3 grams or less is a first-degree misdemeanor. More than 3 grams is a third-degree felony. So whereas marijuana, actual marijuana is 20 grams or less for a first-degree misdemeanor, for just synthetic cannabinoids, for fake pot, it's 3 grams or less, because the legislature has found that these synthetic cannabinoids are in fact more dangerous to one's health than just normal marijuana.
But the challenge now is that manufacturers have skirted the law by changing the compounds and labeling the packets as herbal incense, not for human consumption. So the challenge is that these new formulas of synthetic cannabinoids and bath salts have been developed that are made up of chemicals that are not covered by the current law. So the current law has to keep up with the manufacturers that change the molecules in the chemical compounds so that they're able to distribute. And there's become a huge black market for those individuals that are able to sell these types of substances.
So let's talk about driver's license. And we're going to talk about teen drivers in general and just driving as a right or a privilege. Driving is a privilege because it can be revoked. If you make a certain amount of infractions within a given amount of time, or some serious infractions, your driving privilege can be revoked by the government. We'll get to that a little bit later. But now let's just talk about, is it a big deal to drive without a license? So here's just some statistics about us teen drivers. I know I'm 16, I have my permit, I'm about to get my license. So I'm one of you. I'm driving, I'm a teenager. But we're not the best of drivers, actually. And here are the statistics. Teen drivers aged 16 to 19 are 4 times more likely as adult drivers to get into an accident. And motor vehicle crashes are the leading cause of death among all teenagers 15 to 20 years old. And then 3 out of 4 teens, while killed in a motor vehicle accident, were wearing their seatbelt. So the simple answer is always wear your seatbelt. And while we're not the best of drivers, just try to obey the law and obey the rules of the road.
They're scary statistics, but the problem with the driving is that many individuals don't take it serious enough. Well, guess who does? The legislature. And unlicensed drivers, the law mandates adult sanctions. So if you're a juvenile, if you are under the age of 18 and you commit an offense involving your vehicle, you will be in adult court. It's unlawful, as we know, to allow someone to drive your car if he or she does not have a valid driver's license. It's a second-degree misdemeanor, up to 60 days in jail. There is no, I just went around the block defense. Parents, there's no safe zone when it comes to kids. You, as the parent, can be charged with permitting an unauthorized minor to operate your vehicle. So you're not protected either. And if the unlicensed driver is involved in an accident, your license will be automatically be suspended for 1 year.
Now let's just talk about alcohol, which is another recurring theme in teens' life. And it's another big problem. So we're going to talk about these different scenarios. The first one being, what if your friend brings alcohol into your car, but you yourself are not drinking?
The operative word is the open container and possess, not just not consume. So the question becomes, just like we talked about the possession of marijuana, the question becomes, who's possessing that open container? So let's look at the definition of open container. You're the driver. The open container is one that's immediately capable of being consumed from, or the seal is broken. Well, that red cup, that sounds to me like an open container. An open container is considered to be in the possession of the driver if the container is not in the possession of a passenger and is not located in a locked glove compartment, locked trunk, or other locked non-passenger area of the vehicle. So we're going to look at what the penalties are for underage drinking and whether you can drink during a religious festival. Possession of an alcoholic beverage by a person under the age of 21, the first offense is a second-degree misdemeanor. The second offense is a first-degree misdemeanor with a maximum of 1 year in jail.
So this is something else that all teens seem to inquire about, is that they believe that they have a right to drink for any given religious festival, whether it be Shabbat or if they go to church or any other religion. And the fact of the matter is that alcohol consumption for teenagers is allowed in 31 states, but Florida isn't one of them.
We've actually gone through the 4 top of Jacob's top 10. Now we're getting to number 5, and that's open house parties. Some parents may think that my kid's going to drink anyway, so I'm just going to allow him to drink in my house because at least I can see him and I can take control. And I'm not here to preach what's morally right, but I can tell you with absolute certainty that it's legally wrong. There is no law that permits you to allow your underage child to drink in your home. So let's look at an unfortunate incident of an open house party.
New at 11, parents of 2 Boca Raton teenagers face charges after a homecoming party at their $1 million home.
The party ended with 5 teenagers arrested for underage drinking, others hospitalized, and 4 teenage girls found unconscious on the front lawn. It happened Sunday night at a home on Ibis Point Circle in the Sanctuary development. News Channel 5's Rochelle Ritchie has been following this story and has more on the parents who hosted the party and the fallout. Rochelle?
Well, Jim and Kelly, according to the police report, the owners of the home held the party at their sanctuary mansion for their 2 sons who attend American Heritage School. Now, the parents hired security and 4 charter buses to pick the kids up and bring them to the party. Pictures taken by Boca Raton police show bottles of alcohol on one of the counters. A keg was found on the Rasabi's property, and police say they removed alcohol from a blue bag left outside. All of this has American Heritage parents outraged.
That's horrible. They should be ashamed.
8 officers responded to a medical emergency call from Sanctuary Security just before 12:30 a.m. In the report, police say when they got there, 100 people, all who appeared to be underage, were outside of the home drinking. Several could be seen vomiting, and 4 teenage girls laid unconscious in the front yard and had to be taken to the hospital. Police say they saw another 500 underage drinkers inside the mansion. Police found the parents, Shalomo and Jeannie Rasabi, inside their bedroom, who told them they had no idea that many people came to the party or that there was alcohol. Jeannie told police she held the homecoming party for her 2 sons and that she and her husband stayed in their room the entire time. The headmaster for the American Heritage School in Delray Beach says contrary to previous reports, the Rasabi sons cases do not attend their campus, but are students at the Plantation campus in Broward County. The school released a statement tonight saying they are looking into whether school policies were broken. Parents say they are furious to know adults would hold such a party and stay in their room and not make sure the kids are behaving and are safe at their home.
That is total negligence, and it's ruining our school, and I hope it doesn't affect any of our children's chances of getting into better schools.
The couple was arrested and released and were given a court date to appear. We tried to reach them by phone, but their number has been disconnected. And the American Heritage School says parents should communicate with each other to confirm arrangements and supervision when their children are participating in off-campus activities not involving the school. Live in Boca Raton, Rochelle Ritchie, WPTV News Channel 5.
Let's look at the definition of open house parties, which is a social gathering of minors at a residence where alcohol and or drugs, because let's not forget it's also drugs, are possessed or consumed by the minor, and the person fails to take steps to prevent the possession or the consumption. Right now it's a second-degree misdemeanor. Miami-Dade County has enacted an ordinance that pretty much mirrors the state statute, but that is the maximum penalty. But if you go upstairs or you shield yourself from what's going on downstairs and you allow the alcohol to be there, you can be charged with a violation of this law.
So now we're going to talk about tobacco, which is another big problem. If you're under 18 and you're just holding a cigarette or a cigarette pack, but you're not smoking them, you still can get in trouble. I can tell you, at camp, one of my friends, he thought it would be really cool, and he always walked around with a pack of cigarettes in his back pocket to look cool for other people and for girls specifically at this camp. So if there was a cop that walked by and asked him for his ID and saw that he was 16, he could get in trouble with the law, even though he was not smoking them and he just didn't smoke cigarettes in general. So this is the law. Possession of a tobacco product by a person under the age of 18. It's non-criminal conduct that will require a court appearance. It can result in the suspension of the teenager's driver's privileges and also community service, a fine, and an education course. Another issue is fake ID cards.
Possession of a counterfeit license. It's a third-degree felony with 5 years in state prison.
So in addition to the penalty for possessing a fake ID, I know a lot of my friends go to clubs and bars nowadays, and I ask them, how do you get in? And I expect them to say, I use a fake ID, but some of them use their older brother's ID or their friend's ID. So it's not a fake ID, it's a real ID, it just belongs to someone else. So it actually doesn't carry the same penalty as a counterfeit ID, which is a third-degree felony, 5 years in prison. It's just a second-degree misdemeanor, but it still carries with it the possibility of 60 days in prison. So whether it's a fake ID or just blatantly not your ID, it's still a penalty. It's either one penalty or a more severe penalty.
So now we're going to get to our next issue, and this involves a girl that basically had everything in life until this night.
We're now seeing the evidence against a 19-year-old UM student charged with being drunk behind the wheel when she hit and killed a woman. That evidence includes a fake ID and her own statement she gave to police right after the crash.
The teenager also told investigators she was supposed to be the designated driver that night. Local 10's Glenna Milberg is live now in Coral Gables with these documents for us. Glenna.
The designated driver, Calvin Laurie, it's all right here, designated as the one who does not drink so that she could drive her friends. This account eventually would seem to be disputed by a lot of physical evidence, which is why Ivana Villanueva is charged with DUI manslaughter and here under house arrest.
It's her story in her handwriting. 19-year-old Ivana Villanueva gave to Coral Gables police October 2nd in the hours after she slammed her new Audi, some 80 miles an hour, police say, into Ida Ayala's red Ford, a fatal crash for that grandmother.
It's a catastrophe. There's no word for what we're going through.
In her account, Villanueva gives no clue to what her blood alcohol results would eventually show, that she was almost 3 times the legal limit of drunk. In fact, she writes it was her turn to be the designated driver for her friends. She describes their night partying at several clubs inside the Fontainebleau Hotel until, Villanueva writes, she decides to leave to make 4 a.m. curfew. State's evidence we obtained today shows what police found in Villanueva's car after the crash: a plastic bag with what they suspect was marijuana, her passport, and an Arizona state state license, the suspected fake ID prosecutors think she used to buy cocktails during that night. Bar receipts show the 19-year-old, not allowed to legally drink, bought shots of high-end tequila that night.
This is a horrible tragedy all around. The Villanueva family offers their deepest sympathies.
Villanueva writes, on her way home, the driver in front of her broke quickly, her words. She makes no mention of her speed, but writes, I braked immediately, but not quick enough.
Ivana Villanueva has pleaded not guilty to vehicular manslaughter and DUI manslaughter. Calvin Laurie, until her trial, here she will stay under house arrest with an ankle monitor, but for school and church.
This case is now pending in Miami-Dade County, and it's on its way to trial. But the information that was filed charged 3 counts: DUI manslaughter and vehicular homicide and possession of a false or fictitious driver's license. We know that the possession of the false or fictitious driver's license carries a maximum of 5 years in state prison, and the 2 other charges were second-degree felonies, so she's looking at a maximum of 35 years in state prison. But let's look at DUI, because the DUI offense is a significant offense. And one of the questions that we always get asked is, will a DUI conviction stay on my record? There are very few convictions that carry the stigma of a DUI conviction. It's going to affect college applications, financial aid, your work with the government. You will certainly be in adult criminal court. And it's a conviction, a mandatory conviction that the legislature requires that will remain on your record for 75 years. There's a mandatory driver's license suspension, fines, community service, and probation.
Okay, so there's also another very important distinction to be made here. If you're a teenager, if you're 16 or 17 and you're driving a car and you're able to, you have your license, but you're in your car, any infraction of the law means you will go to adult court. The legislature has found that since you're using a car and a car is deadly, you should go to adult court. They skip juvenile court whatsoever. So any use of a vehicle, even if you're a juvenile, automatically results in you going to adult court. So if you commit any minor traffic violation, or DUI, reckless driving, racing on a highway, driving without a license, or even leaving a scene of an accident, all of those small infractions or serious infractions will automatically place you in adult criminal court and carry with it even more ramifications on your college opportunities, your career opportunities, and really the rest of your life. Any moving traffic violation, if you refuse to take any kind of sobriety test to prove that you are or not driving under the influence, if you break any traffic law and you fail to pay or appear in court, if you use tobacco and you're under 18, or if you accumulate too many driving infraction points within any certain amount of time, that can result in the automatic revocation or suspension of your license.
And when it comes to teenagers, there's zero tolerance here in the state of Florida. Any driver under the age of 21 with a breath alcohol level of 0.02 or higher automatically has the license suspended for 6 months. And any driver under 18 who accumulates 6 or more points within 12 months gets an automatic 1-year license suspension.
So it's also important to understand here that the 0.02, while it's not the 0.08 required for a DUI, it's very, very easy for a teenager to get an blood alcohol level of 0.02. For the average teenager, that's about a half a beer to a full beer. That's half a shot or half a glass of wine. Any of those small sips of wine or beer, any other alcoholic beverage, will give you a 0.02 or higher, and it will result in the revocation of your license.
So number 10 is what we consider probably the most important. And that is something happens.
So just if you do get in trouble with the law, it's unfortunate, but it does happen. Should you let your parents know?
Yes.
Yes.
All right, and a lot of the parents say yes, but how about the teenagers? How many of you think you're going to be able to avoid it? You got stopped for a speeding ticket, they're going to give the ticket, I'll just go to court or I'll just pay it and not think about it. And you should know that, first of all, if you're under the age of 18, the parent or legal guardian is automatically going to be notified of any court appearance. Secondly, if it's a criminal offense, obviously the parent or legal guardian is going to be called. But for those of you that get that civil infraction, that speeding or running a stop sign, and you think you're going to be able to avoid having to tell your parents, you're going to get a flurry of literature from criminal defense attorneys who have the right and have the opportunity, because once the ticket is filed in the clerk's office, it's public record. So they know where you live. You're going to send you a flurry of mail, and your parents are going to eventually find out. We're able to see the bigger picture, and we look at you as teenagers, your life ahead. So it should be the first call that you make. Here's our contact information. If you have any other questions about anything we've talked about today, please give us a call.